Welcome back to The Explainer. Hello to all my favorite student learners out there. Today, we are bringing some serious, upbeat, kawaii-inspired energy to what can otherwise be, well, a pretty heavy topic. We're building a bulletproof mental framework for analyzing product injury fact patterns. So if you've been stressing over how to organize your torts essays, just take a deep breath, grab a cozy drink, because by the end of this explainer, you're going to have a foolproof, super effective attack plan that will help you grab absolutely every single point available on your exam. Let's do this.
Okay, let's dive into this. Here is the visual attack blueprint we'll use to conquer your next exam. 1. The fact pattern alarm. 2. 3 causes of action. 3. Strict liability core elements. 4. The 3 product defects. And 5. Defenses and exam traps.
Section 1. The fact pattern alarm.
So picture this. You're reading a typical torts essay, cruising along and suddenly, boom, a plaintiff is injured by a product. That right there? That is your ultimate trigger. So how do you actually attack a product injury essay? Well, a lot of students fall into a massive trap here. They spot the defective product, they immediately jump into a strict liability analysis, and then they just stop. If you do this, you are literally leaving major points on the table. When analyzing an essay fact pattern, a plaintiff who is injured by a product should raise immediate alarms in your head to evaluate all potential theories of recovery. Professor Burke hit the nail on the head in his course review session with this exact quote: "Products liability is not a distinct standalone tort. Instead, it is an overarching legal category." This is absolutely crucial to remember. When that alarm goes off in your head, it means you've got to evaluate multiple theories under this giant umbrella, rather than just jumping to a single conclusion and calling it a day.
Section 2. 3 causes of action.
Now, what's really interesting here is the core architecture of our analysis. Let's break down your exact essay headings. I want you to memorize this little repetition mantra. Strict liability equals product. Negligence equals conduct. Warranty equals contract. Got it? Let's unpack that. Strict products liability focuses entirely on whether the product itself was defective and unreasonably dangerous when it left the defendant's control. The defendant's fault or mental state? Completely irrelevant. Now contrast that with negligence. Negligence focuses on the defendant's conduct, examining whether the manufacturer, distributor, or seller actually breached a standard of reasonable care in their design, testing, inspection, or warnings. And finally, breach of warranty covers those contractual and commercial guarantees, including express warranties and implied warranties of merchantility or fitness for a particular purpose.
So, looking at this visual breakdown, you can see how this multi-theory architecture splits that overarching category perfectly into 3 distinct paths. And on an exam, you want to walk down every single one of these paths for maximum points. You analyze strict liability first, then you shift gears and analyze negligence, and then, finally, you evaluate the warranties. The whole shebang.
Section 3. Strict liability core elements. Let's shift our focus specifically to the strict liability deep dive. The absolute liability origins for this track actually go way back to the landmark case of Greenman versus Yuba Power Products, which established that a manufacturer is strictly liable when a product proves to have a defect that causes injury. But the crucial point for you is knowing exactly what elements to check off on your exam. First up, proper plaintiff. This can be a user, a consumer, or even a foreseeable bystander. Second, proper defendant. Now this must be a commercial seller. Remember, casual sellers, like your neighbor selling a rusty lawnmower at a garage sale, do not fit here. Next, you need a defective product, and you must prove the existence of that defect at the time of sale, basically when it left the defendant's control. Finally, you wrap it all up with actual and proximate causation and, of course, damages. Notice what's missing from this list? Fault. Like we said, the defendant's mental state is totally irrelevant.
Let's trace that chain of distribution for a second. When we talk about a proper defendant having to be a commercial seller, we mean literally anyone in this stream of commerce. Step 1, the component supplier. Step 2, the manufacturer. Step 3, the wholesale distributor. Step 4, the retailer. Any commercial entity in this stream that passes along a defective product can be sued under strict liability. It's an incredibly powerful tool for the plaintiff.
Section 4. The 3 product defects.
Okay, so now we need to figure out how to actually prove that third element, the defect itself. Under the restatement third of torts tripartite approach, say that 5 times fast, bucket number 1 is the manufacturing defect. This is when a product departs from its intended design. Just think of the mantra, one bad unit out of a good line. A fantastic illustration of this is the Lee v. Crookston Coca-Cola case, where a specific glass bottle failed and exploded during normal handling. In these kinds of cases, because you often can't isolate the exact mechanical flaw after the thing is shattered into a million pieces, plaintiffs frequently utilize the doctrine of res ipsa loquitur to infer that the defect must have existed when it left the bottling plant.
Moving on to bucket number 2, the design defect. Now listen closely to this distinction because it's tricky. Here, the product is built exactly as intended according to the plan, but the underlying design itself is inherently unsafe. The landmark Barker v. Lull engineering case really highlights this, showing us that a design defect attacks the product's actual blueprint. We aren't talking about just one bad unit anymore. We're arguing that the entire manufacturing line is unreasonably dangerous.
But how do courts actually measure if a design is unreasonably dangerous? Well, they generally use two main tests. The older Restatement Second favored the consumer expectations test, which just asks, did the product fail to perform as safely as an ordinary consumer would objectively expect? Pretty straightforward. But the modern Restatement Third approach uses the risk-utility test. This is a much deeper cost-benefit analysis where the plaintiff usually has to prove that a reasonable alternative design, or a RAD, existed. The Evans v. Lorillard tobacco case brilliantly illustrates this clash. In Evans, the manufacturer tried to argue, hey, everyone knows cigarettes are dangerous, so consumer expectations were met. But the court applied the risk-utility standard instead, showing that because a technically viable, safer alternative design, specifically denicotinized tobacco, was totally feasible, the manufacturer couldn't just hide behind general consumer awareness, a real game-changer.
And finally, bucket number 3, failure to warn. This happens when an inherently risky product lacks direct, clear warnings or safe usage instructions for non-obvious hazards. What's really fascinating here is the McConnell v. Costco case. It proves that a warning defect isn't just about sticking a bad warning label on a box. A seller's negligent delivery, like say simply discarding a factory instruction manual before handing the product over to the consumer, can absolutely trigger liability, even if the underlying product design is flawlessly perfect. Basically, an information defect is still a product defect.
Section 5. Defenses and exam traps.
All right, we've built the prima facie case. Now let's anticipate the defenses and traps that bar examiners absolutely love to throw at you. First up, misuse. If a plaintiff misuses a product in a completely unforeseeable way, sure, that is a defense. But, and this is a huge, bolded, underlined but, manufacturers remain strictly liable for foreseeable misuses of their products. Standing on a wobbly dining room chair to change a light bulb? Yeah, probably a foreseeable misuse. Next, open and obvious dangers. Things like the fact that a sharp knife will cut you. There is no duty to warn about those. Then there's the learned intermediary rule for prescription drugs. The manufacturer actually fulfills their duty by warning the prescribing physician, not the end patient. And finally, idiosyncratic or allergic users. You only have a duty to warn if a substantial segment of the population is affected or if the potential health consequences are extremely severe.
Let's wrap up this explainer with a provocative question to chew on before your exam. If a product undergoes a substantial alteration after it leaves the manufacturer, does that permanently break the causal chain? Or is there a way to still hold the original manufacturer liable? Think about it. Mastering these causal shifts and understanding exactly when a modification defeats strict liability is the ultimate key to conquering torts. So keep this blueprint front and center in your mind, always evaluate all your theories of action, and ask yourself, what hidden traps will your next fact pattern reveal? Thanks so much for joining me on The Explainer today, and happy studying.